Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Ismail Arif Mukriz, 2312241. Now I'm going to summarize the news that is related with the public nuisance. So this news is about the business operators along the Jalan Kenari 11 in Bandar Puchong Jaya are urging for the road to be reopened. It is because it is citing significant negative impacts on their business since its closure a year ago. The road was closed due to reduce the congestion from Damansara Puchong Expressway to the commercial area. Lawrence Chu, chairman of a Zone 14 Residents Representative Committee, proposed that the road to be opened from 9:30 to 4:30 p.m. to mitigate these effects. He noted that many businesses have either closed or are considering relocation, and the closure has also increased several times to the local police station, which proved about the safety risk. So the business owners reported significant drop in revenue and staff resignation due to decreased customer access. James Au from a home appliance store and Roy Chong from a nearby restaurant both highlighted substantial loss and reduced customer traffic.
Next, moving on to the example of case related to this topic. In this particular topic, you can refer in the case of Koperasi Pasaraya Berhad and Uda Holding Sdn Berhad and another. In this case, it involved the plaintiff and the defendant. The plaintiff is the owner of supermarket business, which is Koperasi Pasaraya. The defendant is Uda Holding Sdn Berhad and others who were causing public nuisance. And legal issue that we can ask in this particular case is whether the defendants had jointly acted unreasonably, causing public nuisance to the plaintiff. On top of that, briefly explained about the material facts in this case. The plaintiff was running a supermarket business on the ground floor of a 19-story building at Jalan Haji Hussein, Kuala Lumpur. The main entrance to the supermarket was at Lorong Haji Hussein, where 35 car parking were located. The defendant declared and categorized that part of the Lorong Haji Hussein to the plaintiff adjacent to the plaintiff's supermarket as temporary occupational license (TOL). Subsequently, the defendant constructed 76 stalls at Lorong Haji Hussein. The number of customers coming to the plaintiff's supermarket began to dwindle due to access problems by cars and difficulty of parking. The road was only reopened to the public after a period of 5 years. Due to the road closure, the plaintiff's supermarket business suffered tremendously. It therefore had to close its business. Furthermore, referring to the judgment of the court itself, the defendant had jointly acted unreasonably, causing public nuisance, especially to the plaintiff and occupier along the affected public road. The defendant had failed to consider the hardship of a great number of the public road users and occupiers along the public road in favor of a few unlawful traders. The direct consequence of their intended act had caused great loss to the plaintiff in its supermarket business. The defendant had created nuisance to the public, including the plaintiff as an occupier of the road. On top of that, in racial resident part, referring to this case, it can consist of four main racial residenda. The first one is the collective action of the defendant resulted in a public nuisance. This nuisance caused special damage to the supermarket that was different in kind and degree from that suffered by the general public. The second one is the supermarket suffered unique harm that went beyond what the general public experienced. This special damage included to the obstruction of customers' access and disruption of business operation, leading to significant financial loss and eventual business collapse. Thirdly, the defendant's action in closing the road and erecting stalls disregarded to the right of road users and the supermarket. This issuance of temporary occupation license (TOL) did not provide any legal jurisdiction to the public and caused public nuisance or breaching statutory duty. Last but not least, the closure of the road and erection of stalls severely impact to the supermarket's ability to conduct business, leading its financial downfall. The loss of customer access and parking directly caused the supermarket's business to collapse over 5 years period.
Okay, hi, Assalamualaikum warahmatullahi wabarakatuh. I am 2310801, IRSYAD DZIKRI bin HISAMUDIN. So, I will take the role on continuing the second case in our thought election. So, in this case, it is emphasizing the distinction of the principle that we have derived from the previous case. So, in this case, Ranjan Paramandangan and Anur versus Persatuan Penduduk Taman Bangsa Kuala Lumpur, where the parties involved is the plaintiff was the owner and the tenant of a house in Bangsa Park, Kuala Lumpur, while the defendant is the third person who was the association of Bangsa Park. So, the legal issue that have been derived in this case is whether the plaintiff had failed to plead particular of a public or private nuisance to bear its claim. So basically in this case is where the defendant had set up a security system for the neighborhood after getting approval from a third party. But the plaintiff were unhappy with the security system, where they stated that it caused a public and private nuisance and violated the Personal Data Protection Act 2010. As the result, they claimed that the security system was illegal, which allowed the residents association to access public areas without being stopped. But the High Court dismissed the case, saying that the security system was legal and approved by the third party, and the plaintiff could not prove there was a nuisance, which it could be understood that it does not fulfill the requirement that they need. Last but not least, the security system was for the beneficial purpose rather than personal use that could lead to the misuse of it. So now we will get into the last part of our discussion for today, where the ratio decidendi of the case is: first, it was lack of evidence when the court stated that the plaintiff could not prove the act done by defendant is constituted as a nuisance. Second, the plaintiff should file the suit to the relevant parties because of why? The defendant here have get the approval from the third party before set up the security system. Last but not least, the purpose of the security system was for beneficial purposes, which it could help to secure the safety of the neighborhood itself. As the result, the court unanimously dismissed the appeal made by the plaintiff. Thank you. That's all from me. Now I will pass the floor to Brother Ismail to give the commentaries and the judgment of the case. Thank you.
So for commentaries, the case Koperasi Pasaraya Berhad and Buddha Holdings in Berhad exemplifies the application of public nuisance rules by demonstrating how defendants' obstruction of public highway through the closure of Lorong HAZIQ, Husin Tree and construction of stores interfered with public comfort and convenience. This obstruction severely hindered access to plenty supermarket, affecting a significant cross-section of the public, including customers and other roads. The plaintiffs experienced unique and substantial harm, such as financial loss and eventual business closure, which exceeded the general inconvenience by the public. This special damage allowed the plaintiff to sue without needing the Attorney General consent. Under exception in the Government Proceeding Act 1956, the court's decision which favoured to plaintiff highlighted the unreasonable action of the defendants and their neglect of public hardship, reinforcing the principle that public nuisance law protect business from significant disruption caused by improper public infrastructure changes. As for the case of Ranjan Paramalingam and Persatuan Penduduk Taman Bangsa Kuala Lumpur, it is subjected with the application of public nuisance rules, focusing on two key elements, which is interference with comfort and convenience and the impact of class people. The plaintiffs claim that the neighborhood security system constitutes a public and private nuisance by interfering with their reasonable comfort and convenience. However, the court found that the security system, which was legally approved and intended for safety, did not amount to a nuisance. The plaintiff failed to prove to provide specific details or evidence of such interference. Additionally, they could not demonstrate that a significant cross-section of a neighborhood was adversely affected. The court also dismissed their PDPA claims, noting that non-compliance with PDPA should address through PDPA Commissioner and the security measures were legally authorized under the Local Government Act. This case underscores the necessities of providing clear evidence and detailed claims to substantiate allegation of public nuisance and direct specific legal grievance to appropriate authorities. So last but not least, we're going to compare about the law of comparison between the UK law and Malaysian law. So the comparison of public nuisance law between Malaysia and other countries, notably the UK, reveals several significant differences in legal approaches and requirements. In Malaysia, unlike the UK, there is no stipulation that special damage must be proven by the claimant beyond what the general public experiences. Additionally, Malaysia doesn't recognize certain defences such as prescription and voluntary non-fit injury which are accepted in UK. Furthermore, the Malaysian definition of public nuisance is broader, encompassing acts or omissions that affect public comfort and convenience without necessitating harm to specific class of people. Unlike the UK's more specific requirement. Despite these differences, Malaysian courts adhere to common law principles in nuisance cases, as evidenced by decisions like Government of Malaysia and Akasa bin Ahad, reflecting the country's unique legal framework in addressing public nuisance issues.